Good morning, everyone. I'm going to welcome everyone to the Senate Judiciary Committee. I'm going to open us up for public hearings. We have a number of individuals that are going to be testifying today. I want to thank everyone that's made it here bright and early at 8 o'clock. What we are going to be asking are a few ground rules. We have posted this not knowing exactly how many individuals we're going to be wanting to testify. And so we are at this point wanting to, and we have posted it for 2-minute limitation on your testimony if you're going to be giving testimony. You do have the ability to add anything or supplement your testimony through written material. I will leave the record open. Today is Wednesday the 6th. We'll leave it open until 5 o'clock tomorrow. So if you want to add additional testimony, you have until 5 o'clock tomorrow to get that onto the OLIS system. If you need assistance in how to do that, please check with our staff and they'll be happy to help you accomplish that. If you have written testimony already submitted, please come up here and talk from your heart as to what you want to share, summarize. You do not need to read your testimony into the record. It's already part of the record. And lastly, I understand that there are a few individuals that may have some, what I'm going to call somewhat graphic photographs. I've not seen those at this point. Let's kind of keep in mind a few things. This is hearings only. This is for taking in testimony as to whether or not any of these matters should move forward. Graphic photographs regarding child abuse is, from the chair's perspective, is not a subject matter for here. What we're talking about for the most part is custody issues, and that's what we're asking you to please limit your testimony to and reflection. If you want to make assertions, claims, or whatever as to something might happen, clearly feel free to do so. And lastly, I know that this subject matter is very sensitive to many people. Please remember that all of us are here to hear testimony. We would like for you to respect each other. If you hear something that you don't really agree with, please don't respond to it. Please, as Oregonians, allow them to speak. If I find that it's too offensive and stuff, I will take care of the best I can as the chair of the committee. But we're here to give everyone the opportunity, an equal opportunity, to present their testimony today. So if we could do that, that would really be great. I know that we have an overflow room in D, and so there will be individuals that will be coming in to testify potentially out of that room, and so we'll be calling people by name and giving a heads up that someone else is coming up so we can try to get people coming and going. So I do believe I have some members or not?
Yes, they're here on 318.
All right, and then the other four we're going to open up together. Mm-hmm. All right, so what I'm going to do is this. We're going to be jumping around a little bit. I have legislative members who have obligations in other parts of the building. I'm going to open it up for those individuals to come in and give testimony. Hopefully they will also try to do their best in honoring the 2-minute rule, because I'd like to hear from everyone else as well. So with that, what I'm going to do, I do believe I have Rep. Brock Smith here. And David, you have it says plus Steve Green. Who is he? Is he a constituent?
Yes.
Okay, I'd like to take his testimony later. I'm trying to just get members in here so I can get other people. I'm going to open up a public hearing for Senate Bill 318. And Representative, go ahead.
Thank you, Chair Brzezinski, honorable colleagues. Representative David Brock Smith, State Representative District 1, Charleston to West Roseburg, West I-5 down to Cape Junction back over to the coast of Brookings Harbor. I sincerely want to appreciate Senator Thatcher and Senator Manning for bringing this legislation forward. I won't belabor the testimony because there's plenty of fathers here that would like to give their testimony. We all know, and it's in the record, that broken homes are very difficult on children. And as the child develops, it's very important, especially to make sure that there's still the relationship between both parents. And so as you bring this bill forward, I hope that you will continue to understand that and really listen to not just my constituent, but all of the fathers that are in this room And I want to thank you, senators, again for your willingness to bring this legislation forward. So I'll leave it to the fathers behind me to bring their testimony. Thank
All
you,
right,
Senator.
thank you very much for your testimony. I'm going to recess Senate Bill 318. What we're going to do is I'm going to open up the other four because I have a group of individuals we can get in and get out that are here to testify on multiple of those, and then we'll get into the back to 318. So I'm opening up a public hearing on Senate Bills 356, Senate Bill 371, Senate Bill 385, and Senate Bill 736. With that, I'd like to call up Joseph Cowles and Kate Richardson. And Addie, if you can give us some background on all of those so we can just get the record straight.
Absolutely. Chair Brzezinski, members of the committee, this slate of bills comes to you from the interim work group on that explored concerns on Oregon custody and parenting time statutes. So we have before us Senate Bill 356 that allows for a parenting plan to include requirements as to whether the custodial parent must notify the non-custodial parent regarding specific matters concerning the child and or allow the non-custodial parent an opportunity to comment on matters. Senate Bill 371 directs the Department of Justice to create a pilot program to provide qualified and compensated court-appointed counsel in disputed domestic relations cases. We do have -2s in front of us on 371 that switches that over from the Department of Justice to the Office of Public Defense Services in collaboration with the Judicial Department. It also clarifies that those cases would be limited to contested parenting time and custody disputes, not the whole bandwidth of domestic relations. We have Senate Bill 385, which creates an informal alternative dispute resolution process where if during the process the parties do not reach agreement, the conference officer can still develop a stipulated agreement on any resolved issues and or make recommendations to the court on contested issues. We have -1s in front of us on 385 that make these conferences more informal, provide notice requirements, and ensure that safety concerns are addressed. And then finally, we have Senate Bill 736. That bill defines custody, joint custody, and parenting time, and it makes corresponding and conforming changes throughout the Oregon statutes.
All right, thank you. Joseph, I know looking at the meeting materials that you've already have your PowerPoint posted, you are limited for these four bills to 2 minutes. We'll bring you back up for 318, so please hold off on your 318 presentation, and I'm going to go ahead and let you get started.
So what am I discussing, 318 or 371 or 736?
Any of the other four bills, not 318, because we're going to go back through that. And what I saw, that what you had up there looked like it was for the 371.
All right.
But I guess what I'm saying is, remember, for 2 minutes, the PowerPoint's here, we'll look at that, and please just give us the highlights of what you want us to focus on.
All right. You had said 318, so that's what I had prepared for. I apologize. Well, thank you for your time today. A child's voice. It is common for a child to have a legal voice in other states and other countries. In the state of Oregon, there is no age where a child has a legal voice. Without a children's voice, difficult environments can go unnoticed. Children can speak to their true environment. They are the ones living it. There's a global silence with the state here, and it's the same people. I've been involved in 2 work groups. The same people were invited into those work groups, and they're in the room now, and that's where the resistance lies, and I have no doubt about it.
Joseph, just for the record, you need to put your name on the record.
Joseph Cowles, I reside in Lane County, Oregon.
Thank you.
My son wanted a legal voice. He was 11, almost 12. He wrote a letter to the presiding judge of my county and was appointed an attorney. The attorney told him that it would not be good for him to testify in the court. He would testify on his behalf. My son was disappointed because he wanted a voice. A judge also said that it would not be good for my son to testify in court. The ultimate decision was that my son did not testify in the courtroom. I do not see where it is bad for a child to speak to a judge, possibly in closed-door chambers, asking open-ended, high-gain questions to understand what the child's environment is. You have 2 parents on both sides. They have, in some cases, a lot to gain or a lot to lose. The child is placed in the middle as an award, and it creates an ugly battle. Children are not property, they are people. Children need a voice about their environment. Appointed child advocates, child attorneys, guardian ad litems can save children from difficult living environments, abuse, and even death through filicide. A closed-door conversation with a judge in lieu of third-party representation can eliminate the confusion, the third-party representation, and the parents, the noise from those parties. Similar to therapy appointments or a visit to the doctor, it does not have, if it's taboo in the state, and it doesn't need to be. As I mentioned, in other states and other countries, it is not. Next steps, amend the bill to possibly a 2-year pilot as opposed to 5. 5 is super extensive. Pass the bill and implement the pilot. Thank you.
Thank you. Kate?
Good morning, Chair Przonski, members of the committee. For the record, my name is Kate Cooper Richardson. I'm the director of the Oregon Child Support Program and director of the Division of Child Support at the Department of Justice. I'm here to speak very, very briefly on Senate Bill 371 and Senate Bill 736. I've submitted written testimony. On Senate Bill 371, we had requested a couple of amendments. Those have been addressed in the -2 amendments, and we support the bill. And Senate Bill 736, we are at this point neutral in the bill in that it needs still some more work. There are some potential, well, there are definitely some unintended consequences in the bill as drafted, and we would like to continue working with the other stakeholders to get that bill ready for prime time. We do support the concept. That concludes my testimony, unless there are any questions.
Any questions for the panel? Thank you all very much for coming forward.
Thank you.
Joseph, we'll get you back up on 318 in a moment.
Thank you.
All right, so my last panel for these other 4 bills are going to include the following: Eric Dietrich, Sybil Hebb, Ryan Cartley, and Isla Hoffer. So, 4 of you would please come forward. And whoever would like to start, just please put your name on the record.
Go for it, Ryan. Senator Przonski, Vice Chair Thatcher, members of the committee. My name is Ryan Carty. I'm an attorney in private practice here in Salem. My practice is devoted entirely to matters involving family law. I'm also the legislative liaison for the family law section of the Oregon State Bar and the chair of the legislative subcommittee for the family law section. It is in my capacity with the Oregon State Bar that I am appearing on these bills today. I'm going to testify on 356, 371, 385, and 736. These are all bills that came out of that work group. I was a member of that work group and worked extensively on all of these concepts. The section provided commentary and involvement throughout the process as well. The family law section absolutely endorses Senate Bill 356. That's a positive move forward for Oregonians and creates a notification process that the court can include in parenting plans, one that's good for families, good for children, good for parents, and just all the way around good for Oregonians. As for 371, the section had a number of concerns, primarily with DOJ versus OJD administering the program, and also whether that would apply to administrative proceedings. It's my understanding that the -2 amendments address both of those concerns, and so with those concerns being addressed, the section endorses that bill as well and asks you to move it forward. For Senate Bill 385, this is the establishment of a voluntary alternative dispute resolution conference for both modification and enforcement proceedings. And I would point out or point your attention to Section 2 of Senate Bill 385 that has a requirement that the judicial officer appoint a conference officer who is both admitted to practice law in the state and has completed 40 hours of mediation training within the preceding 6 months. The bar's concern is as an ongoing matter, and I know I'm out of time, but I'm testifying on 4. May I continue?
Please.
The bar's concern is that as a practical matter, imposing that sort of requirement, at least as it reads, on an ongoing basis. So you've got an otherwise qualified individual who's a member of the bar and who has completed 40 hours of training, but as it reads, every 6 months then would need to go and complete additional training. That's a pretty stringent requirement on an ongoing basis. when members of the bar are already subject to continuing legal education requirements, and one that may, particularly in rural counties, present a significant barrier to finding competent officers who can hold these sort of conferences and promote the goal. So the bill as a whole, the section supports. We hope that this committee will move it forward and ultimately pass it. But we'd like to see a change to Section 2 to make it more approachable for members of the bar who can fill this role and be appointed by judicial officers. What we'd really like to see, and I'm happy to work with members of the committee, legislative council, to redrafting an appropriate -1 amendment. But what we'd really like to see is that the judicial officer in a district simply have the authority to appoint an appropriate person for that role. On 736, I will join my colleague Kate Richardson Cooper in stating that the section by and large supports Senate Bill 736. It's a positive move forward in further differentiating between concepts of custody and parenting time, custody being legal decision-making authority and parenting time being ongoing contact with the child. It's a fantastic bill and one we support. However, there are a number of as Ms. Richardson stated, unintended consequences. The bill needs a little bit of refinement. I believe that refinement can occur through a -1 or subsequent amendments, and so the section would simply like some additional time to work on those amendments, move the bill forward without creating some of those unintended consequences. I'm happy to answer questions if you have questions about what those are,
right.
But for today, I'll just end right there.
Thank you, Ryan. Who'd like to go next?
Go ahead.
That's good enough, Sybil. That's very, that's one thing I didn't tell everyone. The microphones are extremely sensitive, so you don't need to be on top of it.
Thank you for the Chair Prasonsky, Vice Chair Thatcher, members of the committee, Sybil Hebb with the Oregon Law Center here to support the Senate Bills 356, 371, and 385, and to, similarly to Mr. Cardy, reflect some mixed feedback with respect to Senate Bill 736. From the Law Center's perspective, our clients are extremely low-income individuals. 34% of our cases are family law cases. It's a huge need, and the ability to have assistance and help in figuring out how to access the court system and come up with solutions that work for individual families is a huge priority for us. We really appreciate the focus of this committee and the work group that met during the interim, and I was a part of that work group. We appreciate the focus in trying to get better access to assistance for families as they navigate what can be very complicated court systems. So for that reason, Senate Bill, I have to look at my cheat sheet, Senate Bill 356 creates greater flexibility, or clarifies really that the current law provides the flexibility to judges to make orders around notification by one parent of another parent regarding certain types of decisions. We think that's a good policy. It happens, it works well currently. We'd like to codify that and make sure that that is clear in the statute. Allowing a pilot project, or funding really a pilot project to allow the appointment of qualified attorneys to represent children has great benefits in high conflict cases especially. I would voice extreme support for having training requirements, but I agree with Mr. Cardy's comments that there needs to be some flexibility there to make that work. And just quickly, with respect to Senate Bill 385, which is the ability to, at a court's local option, to appoint parenting time conference coordinators. We think that's a really, really beneficial service for parents in trying to navigate custody or parenting time disputes. The only thing that I would request is that I think unintentionally the bill is currently drafted such that a court would be able to require these conferences in Family Abuse Prevention Act proceedings. I don't think that was the intent. I think the intent was to have that in larger custody and parenting time disputes, so we could just make a quick clarification. And with respect to Senate Bill 736, we think it's appropriate to have better definitions of the terms custody and parenting time in our statutes. It was sort of shocking to me to realize there wasn't actually a specific definition for those terms, and I think for parties trying to figure out what the statutes mean, it's very helpful to have it written down. There are, I echo the concerns about other technical cross-reference and other unintended consequences, so would really welcome the opportunity to be a part of those discussions.
All right, thank you very much. Who'd like to go next?
Oh, I will. Ayla Hoffler, Washington County. Good morning, Chair
Good morning.
Brzezinski and Senators. Thank you for hearing us today. I would just say that on Senate Bill 371 for Children's Legal Counsel, I hope that we go, I was on the work group as well. I'm a nurse for 40 years, teacher K through 12, and a minister. So I've kind of been in the sea of humanity for many years. And I would like to see that we clarify this, that we are expressing the voice of the child's request, that this person is not going to be another one bringing their ideology and their perspective of what's the best interest for the child to this child's advocacy, that they do what the child wants, and we don't need one more person with their opinion on how the world should run, that we're there to represent what the child wants. And I would amend this to say that a child at the age of 9 or at the end of 3rd grade has a right to make an appointment and actually check in and have some voice. And again, at age 14 or before starting high school, they should have another chance to voice what they would like to do with the time with their parents based on their educational needs, their athletic needs, social needs, employment needs. Children know what's going on in the world, and they need to have a right to be heard as their own people. Senate Bill 356, it's a nice idea to give some definitions to terms, but they're terms that we shouldn't even be using anymore. Custody and visitation are archaic, and a visiting parent is an oxymoron concept. If you're either parenting or you're visiting. So to gently flavor these words with, new language doesn't change reality. You walk into a police station, if you're not a custodial parent, they'd say, go to the court. We have nothing to do with you. If you want to do something to help people, start clarifying with school lawyers, the attorneys for the school districts, and get everybody on the same page in the state. We need valid and reliable criteria and uniform statewide criteria for parenting plans. Senate Bill 385, I think that's a great idea. I hope it costs a lot less money than an attorney and a home evaluator. They should be able to enforce 50-50 time immediately, and that they should be able to penalize somebody that's in contempt of what that order and that law reads. No more saying, go to court and file a complaint. If you're not giving the other parent 50% of their time, you ought to be thrown in jail. It's the law. That's what Senate Bill 318 will do.
I need you to wrap up, please.
Yes. Well, I got 4 bills. I'm still doing all right.
Yeah.
Bill 736, custody visitation. It's a conflict of interest. You're saying you have these decision-making rights, but if you're a non-custodial parent, guess what? You don't. So it doesn't really mean anything. As long as you keep these words custody and non-custodial, you're a conflict of interest. And once again, it has no standing with law enforcement. Thank you.
Thank you very much. Eric?
Chair Brzezinski, Vice Chair Thatcher, members of the committee, my name is Eric Dietrich. I'm here from the Office of Public Defense Services, and we are neutral on the bill. We do see how in these contested custody cases, having a voice for the youth could be very helpful for the bench in achieving a good result. And I do think we're probably the best agency to handle such a program because we routinely do provide access to counsel in other case types, criminal, juvenile, civil commitment, et cetera. There are 2 concerns I have that I don't think need amendments, but things that could be worked out. as part of the standard setting. And one of them is with the issue just addressed. It makes total sense to me that you would have an advocate, pushing the express wishes of the child. But I do get concerned when we start talking about the best interest of the child. My understanding is that this already happens somewhat in courts, whether it's counsel doing the work pro bono or the parents chipping in to get the youth an attorney. They're kind of almost deemed as a special master. They're given great deference in these types of decision making, and so I wouldn't want to have that person substituting what they think is the best interest over the voice of the youth. The second concern is, what exactly are we talking about here? Are we talking about just an attorney providing advocacy for the youth, or are we talking about the full gamut of legal services, such as access to private investigators, psychologists? How deep a dive are we taking in the advocacy we're providing the youth? And the last point I just wanted to make was, and you know this, members of the committee, as an agency, we have a responsibility to provide legal services in certain areas that are constitutionally required, which we are already deficient in. We had a report come out in January, which we've addressed to this committee, that highlights the unconstitutionality of certain aspects of our system. And our commission has directed us to work with the legislature in coming up with a new funding model. And we're doing that with the chair of this committee right now. So we'd want to make sure that we get the legislative reforms we're seeking and the resources we need for the constitutionally required services, before we take on more work.
All right, thank you. Any questions for this panel? Thank you all very much for coming forward. At this point, we've heard from everyone that has signed up for the last 4 bills. I'm going to close.
I was having a hard time switching between the screens for all of the detailed kind of -2 amendment or this piece in section 2. So for people that had those specific pieces of, I'm not there with this, but I do like the -2, if we could have that in writing, it would be helpful, because I couldn't switch between the screens fast enough to get the right notes on the right bill.
Okay, and as everyone knows, that today is public hearing. I'm not sure if you were here before I announced that we're going to allow for written testimony to continue up until 5 o'clock tomorrow.
Okay.
So at this point, I'm closing the public hearings on Senate Bill 356, 371, 385, and 736. So thank you all very much for letting us get through those 4 bills. The last bill we have I'm opening up the public hearing for is 318. I've counted the list. We have about 35 individuals who'd like to testify today. That's about 70 minutes. We're going to have a little bit of flex because I don't want to stop you in mid-sentence, but please try to be respectful. I think we can get everyone in, and if we have a couple more people come in, we'll be able to get those in before we have to take on our other obligations in the legislature. So with that, let's go ahead and bring up, and I'm going to go ahead, and the other thing we do is that we try to make certain everyone that has traveled to great distances are going to be able to testify. I believe on the timeline, we should be able to get everyone in. So I will go just basically from top to bottom on those who signed up, more kind of a first come, first serve, and we'll see how we'll go with that. So the first panel of 3 will be Suzanne Zane, Elijah Goodrick, and Brandon William, I believe, or I think that's William. Yeah, and we're going to get an overview from Addie, and then we'll take the testimony.
Chair Przanski, members of the committee, Senate Bill 318 creates a rebuttable presumption that equal parenting time is in the best interest of the child and creates standards and procedures to rebut that presumption.
Who would like to go first?
I'll go ahead.
Okay.
I'm Dr. Suzanne Zane, and I am a resident of Multnomah County. I'm the senior maternal and child health epidemiologist for the Oregon Health Authority, and I've been a public health scientist in that field for 2 decades within a major federal public health agency. My work here focuses on how to support the health and well-being of children and families throughout Oregon. But today, I'm here to testify specifically as a private citizen against this bill. This is a bill that would have a lot of unintended consequences. I would like to live in a world where all parents could share parenting 50-50 and maintain a conflict-free environment for their children after divorce. Unfortunately, this is not a common reality. Many of you have heard of ACEs, adverse childhood experiences, which are forms of trauma which are shown to influence psychological and health effects through childhood and long-term into adulthood. Divorce is considered one of those ACEs, but damage to a child from the effects of divorce really vary depending upon the circumstances. A good outcome for the child depends upon the ability of the parents to collaborate on the child's behalf and create a nurturing, emotionally stable environment. That depends on a lack of conflict, consistency for the child, and good interparent communication. Without these, the effects on children of all ages can be profound. I need to highlight the situation of infants and young children. There must be a primary caregiver or caregivers who are pretty consistently in place most of the time to know the child's 24-hour needs. Consistency and stability are key to the ability to form secure attachments during this developmental period in the young child for all of those who love and care for them. And this includes not only their primary caregiver in terms of time, but their other parent, other caregivers, and loved ones who care for them less of the time. Having a stable primary home in which they feel secure and rooted puts the psychological and emotional development of the child into the place they need to be to grow and develop. Scientific understanding of infant and child mental health needs says that this bill is the wrong approach for infants and younger children. The burden of proof stated as clear and convincing evidence in this bill is far too high. Judges need to be able to apply the statutory factors to determine what parenting time split really is in the best interests of the child. Parents cannot meet this standard based upon this higher standard of evidence stated in this bill due to lack of knowledge of the legal process, resultant fears, and especially cost for lawyers, costs for parenting evaluations, and the need to miss work, among many others. So in closing, the presumption stated in this bill regarding the well-being of children is not factually accurate and may result in damage to the health and well-being of Oregon's children. And I urge this committee to let the family courts of the state work with the law as it currently is to best serve the needs of the children of Oregon. Thank you.
All right, thank you. Is it Elisha?
Yes.
Would you like to go next?
Sure. Hello, my name is Elijah Goodrick. I'm a resident of Gresham, and I am here today as a father of 3 children. In 2009, I was able to finally escape an abusive relationship, and long story short, after a lot of proceedings and a lot of money spent, I was able to enjoy, and my children were able to benefit from 50-50 time with both of their parents. The fact of my former spouse's abuse was never germane to the case. We worked with the 50-50 time split for many, many years, and it worked well for the children, and they were happy. In 2017, the mother of my children filed for a modification, was able to secure a custody evaluator from Multnomah County Court Services who was biased, who lied to me, who manipulated me, and shut me out. I am now relegated to weekend dad. That's not who I am. And that's not what my children need. And it hurts me to see them hurt, the effects that it's had on them, the self-harm that I've watched my younger son do, the anger from my older, because they were put in the middle of their mother's anger. And I encourage you guys to push this bill forward, to allow fathers to be fathers, to allow children to have their both parents who love them and care for them be part of their lives. If you have any questions for me, I'm happy to take those. Thank you.
All right, thank you. And Brandon.
Try to make it short and sweet. Chairman Brzezinski, Vice Chair Thatcher, members of the committee, thank you for having me here today. My name is Brandon T. Williams. I'm a resident of Warrenton, Oregon. That's in Clatsop County. I'm a successful construction contractor. I was a volunteer firefighter, EMS provider. I have 3 beautiful sons, Meech, Malachi, and Judas. Unfortunately, my boys and myself have experienced the cause and effects of fatherlessness and sibling and parental alienation. I've formed unique bonds with all 3 of my children, having been present and active in the delivery of my sons. Being the first person to touch all 3 of my children, I think that's a rare thing that a father can say. I'm in support of Senate Bill 318 for a few reasons. Children need both parents. Essentially, fathers need to be there in the upbringing of our children from adolescence to adulthood and to be productive members of society. Fathers are a foundation built of morals and values for individual, family, and community success. We all know high statistics such as increased school dropout rates, violent crimes, mental health issues, along with drug use, addiction, domestic violence. The warlike posture that our children face today needs to stop. Title IV defunding, the incentivization from the states to the counties to separate families, it breaks my heart. It's ruining our societies. I just want to urge all representatives to affirm Senate Bill 318 and any other bills in its likeness. Chairman, Vice Chair Thatcher, members of the committee, I humbly and thankfully appreciate your time and would welcome any questions.
All right. Thank you. Are there any questions for the panel?
I do have
Senator
one
Thatcher.
question. Brandon, you referred to the incentivization. Can you be a little bit more specific?
My understanding of the Social Security Act Title IV defunding, it creates the incentivization through programs such as welfare, food stamps, to keep families at a level that they're dependent on the government when, quite frankly, in my situation, my family would never be dependent on the government. I'm hardworking, and I've been able to provide my whole life.
Thank you.
Brandon, thank you very much, and the others, thank you very much for coming forward. Our next panel is going to include Stephen Green, Keith Donaldson, and Jason Gearhart. Gentlemen, whoever would like to start, if you just give us your name and then your testimony, please.
Chair Brzezinski, members of the committee. For the record, my name is Keith Donaldson, and I am here in the support of Senate Bill 318. I live in Marion County. If you can recall, 2003, fall 2003, my daughter was on the local, state, and national news. She was going to die. She needed a heart transplant. I went to Loma Linda. They told us to prepare for the worst. She was going to die any day. Luckily, on Thanksgiving Day, ironically, she received the heart transplant. I became a father that day of 2 children, one not being mine. Years later, through the divorce, we figured 50-50. It's fair. The other side said, no, Oregon bare minimum. I have more days now. I had to negotiate for those. I had to give up rights for those. I think that's unfair. I want everybody to know I'm not here for me. It's too late. My daughter's older. I'm here for people I don't know, children I'll never see, because this is not right. The system is broken. When you can take a man or a parent that sits beside their child on their deathbed and look that parent square in the eye and tell them you are not worthy of 50%, members of the board, there is something wrong. And this changes that. This makes it fair. Isn't that what law is all about? Fair. Thank you for your time.
Thank you.
Hi, my name is Stephen Green. I'm from Coos Bay, Oregon, Coos County. I'm a disabled Iraq War veteran. I had a son in 2005. You guys probably saw my testimony I sent through the email. So I won't get into much detail. But I'm also a Little League baseball coach. I've coached for over 8 years. I'm going to tell a quick story about a kid that I invited onto my team. I found just scrolling Facebook one day that had cancer. So I reached out to his mother and said, we'll call him Johnny, like to play on my team? And she says, well, yes, we can't afford it. And I said, well, we'll take care of that. So a few weeks into the season, he joined our team. Johnny, didn't have a father. He just had his mother. I don't know the story. I've coached a lot of kids. I've seen a lot of broken homes. I've seen parents that do the 50-50 thing away from the courts, and it works wonderful. I love it. Unfortunately, my ex-wife isn't about that. Well, unfortunately, this 5-year-old boy had neuroblastoma, which is a bone cancer. And he kind of saw me as a father figure because he didn't have a dad. I don't know what the story was. Every child needs a dad. Every child needs a mother. There's things that a mom can provide that a dad cannot. There's things a dad can provide that a mom cannot. 2 years ago, Thanksgiving, my ex-wife decided she was going to take my son after I'd had him for 7 months because she was sick, and moved to Georgia. She lost her job, so she moved back to her parents' house, took my son. I had every other weekend, whatever the state standard is. That's not right. I coach kids, and I see the effects that they have of not having both parents. And I mean, even if I don't get my son back, I'm gonna fight for all the kids that I have coached and will coach. Thank you for your time.
Thank you very much.
Excuse me. Good morning, Chair Brzezinski, Vice Chair Thatcher, and Senators. For the record, my name is Jason Gearhart. I'm from Tualatin, Oregon, Washington County. Becoming a father was always a dream of mine, especially in the year 2003 as an adopted only child, seeking out my biological parents who were in Minnesota, finding out I had 2 half-brothers on my biological dad's side. I moved back to Minnesota for 3 years, from 04 to 06, and developed a relationship with them, as well as other family members. Now, the tough thing about that was my biological dad and his wife did not tell my brothers that I was their brother. So fast forward to June 2012, I'm living in Oregon again. I'm about to fly out. My biological dad calls me to let me know some big news, that he told my brothers, Cameron and Blair, the news that I was their brother. My one brother, Cameron, the older one, he's 18 now, is autistic, so there was some worry there on how he would handle that, and of course my younger brother got lumped into that. Long and the short of that is my brother Cameron asked my biological dad, Dad, why didn't you tell us sooner? And that's the theme of what I'm trying to talk about here, is missed opportunity, because I have a 2.5-year-old son named Sawyer. The Senate Bill 318 reminds me of this story of my brothers. When there are 2 fit, willing, and able parents in the mix, 50-50 or something relatively close to that seems logical. It seems fair. The nearly 10 years of missed opportunity with my brothers, it negated us from building a healthier family dynamic out of whatever it was, fear or genuine, concern about the children. So fast forward to today, I have a 2.5-year-old son. Last week I had my first overnight. It went great. He didn't clamor for his mom. Everything was wonderful. I made breakfast and we had fun like we normally do. He didn't die. And then last night, the last thing I'll say, I know my time is up. Last night, right before I started writing this, it was time for him to go. And I was at my parents' house, and he did not want to go. He was trying to take my shoes off and not put his coat on, even when I'm saying, it's time to go see mommy. She's here to pick you up. She's missed you all day. Kids need both parents. We got him to his mom. He got calmed down. He loves his mom, and I want him to. But she moved to Willamina, south of McMinnville, so it's going to be hard to do 50-50. So like this gentleman was saying, I'm not just here for me. I'm here for everyone behind me. I'm here for the state, and I'm here for those nationally who just want to have a good relationship with their kids and to build some great things. Thank you for your time. Questions are welcome.
Thank you. Are there any questions? Gentlemen, thank you very much.
Thank you. Thank you.
Our next three will be Greg Culver, David Becker, and that's Isaiah Burrow. Good morning.
Good morning. I'm David Becker. Good morning, Chair Przansky, Vice Chair Thatcher, members of the committee. I'm an attorney from Portland. I'm a litigator. I practice federal and environmental law, not family law. I'm treasurer of the State Bar's Environmental and Natural Resources section, but I'm appearing here today in my capacity as a private citizen. I'm testifying in opposition to Senate Bill 318 because it would enact an evidentiary presumption that has no empirical support and would paradoxically make divorce and custody proceedings less fair than they currently are under the multi-factor balancing scheme in the current law. I want to echo the written testimony of Attorney Andrew McLean to point out that when the legislature includes an evidentiary presumption in the law, it is critical that it be based on overwhelming empirical evidence that the presumption is factually accurate in the vast majority of cases. I've read the written submissions that were on the committee's website as of last night, and although there are many heartbreaking anecdotes describing apparently unfair outcomes under the current system, there are no empirical studies that would begin to justify a legislative presumption that parenting time should be equal rather than judged on a case-by-case basis as under the current law. What's problematic about an unsupported evidentiary presumption is that it imposes a one-size-fits-all standard on a legal issue that is inherently different for every different couple and every different child. Further complicating this is the clear and convincing evidentiary burden for overcoming the presumption. In practice, in my experience as a litigator, this is an evidentiary burden that is much harder to overcome than a preponderance of the evidence or more likely than not standard of proof. This has the potential, as Mr. McLean mentions in his testimony, to lead to more litigation and tragic and undesirable outcomes where one partner with more resources gets an additional thumb on the scale in custody proceedings. To the extent you've heard about problems with the current system, the judiciary should be seeking, the legislature should be seeking other reforms, such as the bill today that gives children a voice but not imposing an unfounded presumption. The legislature should not be in the business of casually enshrining evidentiary presumptions and taking away from the courts their ability to weigh evidence in the best interest of children, making it more difficult or impossible for a parent without financial resources to overcome the evidentiary presumption. I urge the committee not to advance this bill. Thank you.
Thank you. Who'd like to go next?
No. Chair, Vice Chair, Senators, my name is Greg Culver. I live in Eagle Point, Oregon, which is Jackson County. I have in front of me one caseload of 14 years, 767 pages and counting. I've spent over 14 years fighting just to be a parent to my kids. I spent 14 years serving this country and got injured in Iraq. I'm good enough to die for my country, but I'm not good enough to parent my kids. I have heard every excuse from the Jackson County judges on why I cannot be a parent. I have one judge on record has admitted he is biased against me, but will not step down when asked to be recused. I have another judge that allowed my 10-year-old son, who was living with me for the last 7 years, to testify against his mother on child abuse. My son flat out told the judge he wants to live with me. That judge ignored my son's voice and took my son away from me. I went from 300 nights a year to 9 days a month. Overnight, he was ripped away. The judge didn't even listen to my son, and that's what matters, is my son. That's what matters to everybody here, is our children. 318 would fix that. It would take the power away from the judges, take away from all the excuses, and give the power back to the kids. The judge that took my son away openly admitted it is best to have 50-50 parenting time. But yet, he gives an abuser, his mom that suffers from 4 mental disabilities, full custody of my son. And I'm left selling my ranch and striving to be a parent. I urge this committee to really consider and looking at all these documents and all these excuses that as parents and as fathers have to face on a daily basis in the court system.
Thank you.
If you have any questions, I'd be glad to answer them. Thank you very much.
Thank you.
Good morning, Chair Przanski and committee members. My name is Isaiah Burrell, and I reside here in Salem. I'm here this morning to share my testimony in support of Senate Bill 318 because I have 3 beautiful daughters that I know would greatly benefit from the passing of this bill. I'd like to begin with a prayer that Chair Przanski and the members of this committee hear the hearts of the people that are testifying in support of this bill. It's easy to mistake passion, pain, and devotion for anger or aggression. Everyone here is a person with a story, whether a story of pain, of passion for children's rights and equality, or one of pain caused by a judge, an attorney, or a co-parent. But we are all here today devoted to creating a new chapter and changing the storyline by advocating for our children and attempting to change the status quo. Now, consider what this phrase means to you. You are both equal parents. This is a phrase that I've heard from the judge appointed to my case numerous times. I know it's the truth, but as we both have homes, we both have jobs, we attend church, and we love our children dearly. However, because we couldn't agree on joint custody, equal ends up looking like every other weekend with my girls and a few hours during the week. A mediator once told me that bedtime is where the magic happens, and I couldn't agree more. Tucking my children into bed at night, saying a nighttime prayer with them, brushing their teeth, reading them a bedtime story, or comforting them when they have a nightmare and they wake up during the middle of the night. These are all things that are important to my children, they're important to me, and they're important to the development of our relationship. However, these are just a few examples of things that can't happen consistently with the 4 overnights that I get with my children each month. So while the judge assures that we are equal parents, that's not the message to me, that's not the message to my children or to their mother. A child is 50% mom and 50% dad. Our children deserve to be with their 2 parents who equally love them, equally want to raise them, equally are able to care for them, and equally took part in creating them. So the question is, what is in the best interest of our children? Is it really one involved parent and one visitor? Thank you for your time.
Thank you for your time, and thank you for your testimony. Are there any questions? Gentlemen, thank you very much for coming forward. Our next panel is going to be Holly Burrell, Ayla Hoffer, and Ernie Young.
We're already at the last?
No, we're not. This is last on page 1. I've got 2 more pages.
We were going to be last, Ernie and I.
If you'd like to defer your time and meaning come up later, that's fine with me.
We were going to be last. We spoke to Addie about it. We'll let somebody else go before us.
That's fine. Holly, you're here. I'm going to go ahead and ask Phoenix, is it Siga Love? Lore, I can't tell if it's a V or an R, and Joshua Backer.
You're ready.
And Holly, if you'd like to get started.
Yeah. Good morning, Chair Przanski, members of the committee. My name is Holly Burrell, and I reside here in Salem, Oregon. I'm a teacher, a wife, a mother, a stepmother, and a lover of God, and I'm here today in support of Senate Bill 318. I myself have had the opportunity to navigate the family law system for myself, as well as with my husband, who you just heard from, and a number of other male family and friends. I can honestly and frankly say that the results have always been the same. 2 parents who love their kids but don't get along and can't agree go into a courtroom and spend tens of thousands of dollars, which just increases their stress. It increases their disdain for each other, and it increases their bickering. And at the end of the custody trial, at the end of the day, the judge upholds the status quo that
Mom gets custody because, well, historically, she is the social emotional support for the kids, and dad gets parenting time, which often comes along with a large child support and child care bill because, well, historically, dads are the financial supporters. Well, times have changed, and it's time our court systems do too. As I mentioned before, I'm a teacher, and we have seen a huge increase of students with social, emotional, and behavioral issues. So much so that we are teaching these skills in our classrooms along with letters and numbers and sounds and everything else you want us to teach them. So the status quo is failing our kids. And simply put, kids need both parents, and it's backed by study after study stating that the effects of an absent parent, in particular an absent father, is not okay. It's failing our kids. And we're here, the fathers, they're here today. They're not absent. I would say that they're just being pushed out by our system. So Senate Bill 318, it'll help give them a voice, an opportunity to be present with their kids in their lives instead of just financial supporters. Senate Bill 318 isn't perfect, and I'd say that no bill before you probably ever is. So it is a necessary start, and I understand that it takes a lot of courage for you guys to support this bill. I know there's groups that oppose this bill. We've heard from them. They're powerful. They're wealthy. They're afraid of changing the status quo. So I pray that you hear past those fears and that you have the courage to listen through a filter that the status quo is no longer truly what's best for Oregon's kids. I thank you, and I'd take questions as well.
Thank you. And who'd like to go next? Okay.
My name is Phoenix Sigalov. I'm a resident of Jackson County. I want to thank you all for the opportunity to speak here today. I'd like to thank in particular Senators Thatcher and Manning for working across the aisle in a time of such political divisiveness. I very much appreciate that example. I'm here to testify in overwhelming support of Senate Bill 318 because I know firsthand just how important it is to demand equality for both parents in the lives of our children. Far too often, non-custodial parents, mostly fathers, are relegated to minimal time and influence in exchange for the majority of financial responsibility. It is predicated on an antiquated system where mothers are seen as primary caregivers, fathers primary breadwinners. It is in itself based on inequity of gender roles in society, and it is unjust. In millions of cases like mine, fathers are seen as expendable. We are not. 4 years ago, the mother of my 2 children asked for separation. I agreed to give her the space she needed. Without warning, she took our 2 girls from our family home. I did not know their whereabouts for 5 days. During that time, her attorney drew up a painfully limiting temporary parenting plan, which became the precedent over the next year. Over the past 3.5 years, I have been in innumerable courtrooms and spent tens of thousands of dollars battling for one thing: equality and influence, equal time and influence in the lives of my children. The time that I have lost with my girls during their formative years, I can never regain. There are hundreds of statistics which show the direct correlation between fatherlessness and an alarming elevated rate of violence, incarceration, drug addiction, school dropout rates, promiscuity, teen pregnancy, and suicide in children. The gentleman was looking for empirical data. This is it. These statistics are well documented, and they are grave. As the father of 2 young girls, I'm painfully aware of the fact that I have the primary male relationship in their lives, upon which they will base all future relationships with boys and men. I worry greatly how my absence from their lives will negatively affect their future. I would like to add, while this bill addresses parenting time, it does not address custody. As we well know, in the state of Oregon, joint custody between parents is taken off the table when one parent does not agree. In my case, I lost custody of my children of no fault of my own, but simply because my children's mother did not agree. When 50-50 is not the legal presumption in custody and parenting time, the strategy of family attorneys oftentimes becomes to destroy the credibility of the other parent. In cases like mine, false allegations of abuse and character assassination are rampant, and in family court, there is no recourse. I believe strongly that the current laws are directly related to an epidemic in this country that is little talked about. Men are 9 times more likely to commit suicide than women after divorce. Estimates of between 15 and 18,000 non-custodial fathers take their lives each year. I am one of the lucky ones, and although I still have minimal time with my eldest daughter, who is 12, I am heartened that we have worked over the period of 3.5 years to now have close to half time with my youngest daughter.
Phoenix, I need you to wrap up, please.
Yes, sir. I could not have gotten to this point without the steadfast love and support of my partner, who has stood and fought by my side for equality. We urge you to move forward with this bill. Thank you very much.
Thank you. And Joshua?
Good morning, Chair Przansky, Vice Chair Thatcher, senators, constituents, and other invested parents. My name is Joshua Bacher. I live in Newport, and I work for Lincoln County Planning and Development. I took the day off to come and testify in favor of Senate Bill 318, the bill that adds very impactful text or variations thereof to family law proceedings, which reads, presume, subject to rebuttal, that equal parenting time is in the best interests of the child. I have been divorced from my children's mother since 2005, and like many, we disagreed on the parenting plan and custody, a disagreement which unfortunately continues to this day. It is worth noting that I have had full custody of my children twice, but not initially and not currently. It has been a very time-consuming and costly process, which could have been easily avoided had Senate Bill 318 been in effect more than a decade ago. I realize that by having children aged 15 and 16, it is likely this bill will not be fruitful for me specifically, but if I can be a voice for other fathers and mothers that have been treated unfairly in family court, then I will be happy to help. I also believe that in a day and age where gender equality has become so important, it's an appropriate time for the state of Oregon to consider the ramifications of that and not simply automatically find in favor of the mother. I implore any family court system to truly establish that equal parenting time is in the best interests of the child. In closing, I want to thank Senator Thatcher for sponsoring this bill and offer encouragement to the other parents that have been impacted by family law. Hang in there, our voices are being heard. Again, I fully support this bill. Unless there are any questions for me, thank you for your time.
Thank you very much. Are there any questions? Thank you all very much for coming forward.
Thank you.
Our next panel will include Sally Brown, Seth Laser, I guess, and Ryan. Well, I'm going to hold off on those. And is it Michelle Anderson? Who'd like to start?
I'll go ahead. I didn't know I was going to get to talk this morning, so. My name's Sally Brown. I'm from Multnomah County. Thank you for allowing me a moment to speak. I understand the time restraints, and as such, I'll be brief. I would like to lend my passionate support for this bill. I'm here on behalf of my partner, who is working in Alaska for 3 weeks at a time, then home for 3 weeks at a time, so cannot be here. He took this hellish scheduled work when he discovered the mother of his child would be taking their 3-year-old daughter and moving to Hood River, Oregon, from the Bay Area where we all resided at the time. He gave up a promising job as a project manager to do physical labor work on an island in Alaska. Thank you. Thank you. Sorry. Because it was the only way he could move to Oregon quickly, hoping to lose as little time with his precious daughter as possible. Prior to this move, he saw her every single day. So sorry, please excuse me. He commuted in rush hour traffic, a 3-hour round trip, to spend every evening with her.
Since the mother moved, he's seen his daughter for one weekend each month. She has even begun limiting his phone calls. We are horrified by her actions and fearful of the traumatic effect it could have on his daughter. We are presently preparing for court, where we will spend thousands of dollars that could have otherwise been allocated to his daughter's future, all while remaining completely uncertain of what our future holds by the will of a judge. I had some more to say, but obviously I can't get through it. So just thank you so much for your time.
Yeah. So Sally, if you would be so kind to maybe submit your testimony in writing.
I definitely will.
We'd love to have that, please.
Yes.
Okay, thank you. Who'd like to go next?
I'll go next. Good morning, Chair Przansky and members of the committee. Thank you for hearing me today. My name is Michelle Anderson, and I reside here in Salem, recently relocated here from Bend. I am a mother, an aunt, a domestic violence survivor. I'm a non-custodial parent. I'm here today to support Senate Bill 318. The standard model used today in family law is the mantra of in the best interests of the child. The best interest criteria used is not exclusively enforced by all judges. When not exclusively adhered to, like in my case, this sets the stage for further harm to the children. It is a terrible misconception that mothers are granted custody of the children because they are considered the primary caregivers. It is another egregious misconception that an abuser will not seek custody of the children nor win it, especially if there is a police record and a conviction, proving that the abuse had happened. This is the foundation of my case. The standard model is failing children and families by allowing an uneven reality for good and fit parents. As a result, many parents, including myself, are pushed aside and reduced from primary parent to a visitor in their children's lives. 4 days a month is not a reasonable amount of time to maintain and build upon a continued loving relationship for children. This is my son. His name is Nathan. He was bright, compassionate, an all-around beautiful soul of a human being. He took his own life on January 2017, shortly after he turned 16 years old, and after being ordered to live with our abuser 3.5 years before his passing. One parent cannot abuse the other and still be a good parent. I know deep in my heart and without a shadow of a doubt that if I was granted equal parenting time, I would have been able to get the help my son desperately needed, and he would still be here today. Senate Bill 318 grants a reality that I was never afforded. Let me end with this. Chair Przansky and members of the committee, if any of you have children or grandchildren, which one are you willing to live without for the rest of your life? Thank you for your time and consideration on Senate Bill 318, and I hope that you make the right choice for the children of Oregon. Thank you.
Senators, thank you for having us here today. My name is Seth Lazier. I'm co-founder and president of the Parental Equality Network. And most importantly, I'm a parent. I'm a step parent. I'm a non-custodial parent, and I'm a custodial parent. I am here to show my support for 318. Nationally, in 2017, more than 20 states considered laws to finally require shared parenting. That is when I started my journey into all of this. It was Martin Luther King who said, "We begin to die the day we begin to be silent on issues that matter." Divorce and separation in this country almost always means that children lose significant contact with at least one of their parents and their entire other side of their family. Once the judges determine that both parents are good and fit, the best interests of every child would be the courts to enforce even bonding opportunity with both parents and families over the entire 18 years of child development, thus the best interest of every child. In general, it is to have equal and nearly equal time with both parents, especially during dramatic shifts in the family dynamic. This bill would create a rebuttable presumption of equal parenting time in the best interest of all children at the beginning of every divorce or separation. If enacted, SB 318 would provide 50-50 parenting time as a starting point, not necessarily an ending point. the vast interests who endlessly oppose a child's constitutional right to bond equally with both parents often defend the indefensible by cavalierly stating divorce is complicated. Equality has always been complicated, but in this country, eventually we embrace those complications and realize that the worst source of complication is perpetual inequality. Within the next few decades, today's family outcomes, a winner-take-all custody model, which maximizes conflict and reduces children to pawns, will be viewed as being archaic. All children spell love, T-I-M-E. So let's make equal parenting time a real possibility in Oregon.
So thank you very much. Any questions? Thank you all very much for coming forward and sharing your stories. I'm going to call up Justin Stinson, Jeremy Weinstead, and Alexander, I believe it's Mola. And Justin, would you like to start us off?
Sure. My name is Justin Stinson. I live in Marion County. My daughter is 5 years old, product of a 3-month relationship. I signed her birth certificate, and I paid $60,000 of child support in her 5 years. I operated under the pretenses that I had no rights as a father and did not want to go the stress, increased financial stress, and the ultimate letdown. I started my battle for me and my daughter's relationship 3.5 years ago. The first year was without court involvement. The last 2.5 have been through court. It took me 2 years to have any one-on-one time with my daughter. Our relationship has flourished since our one-on-one time started. My significant other's son lives with us just over half the time. He is also 5. I get my daughter for 8 hours a week currently and will ultimately end with every other weekend and 2 hours on Wednesday nights. We told her son about this hearing and tried to explain why we were going. Then we asked him if he would like it if he was only able to see his father for every other weekend. He responded no. My daughter deserves me, and I deserve her. I'm tired of being treated less than a parent and more of an obligation. I am going to have to explain my absence for 2.5 years to my daughter, and that was my fault. The absence of me for 88% of her life, if this bill does not pass, is not mine. It's not my fault. And I will have to have that conversation with her if I must. Co-parenting is hard and requires people to operate with the thought that the other parent deserves as much time as the other. This bill could start that thought, and hopefully that thought will catch on. Thank you.
Thank you. Who'd like to go next?
Yeah, I'll go next. So my name is Jeremy Winstead. I reside in Marion County. I want to thank the council for hearing all of us today. I definitely appreciate all of your consideration for hopefully making a positive change. I'm here in support of 318. I have seen and witnessed way too many times families torn apart and children ripped away from loving parents because of a simple disagreement between the two. Leaving it up to the courts to decide who would be the better fit for the parent is not in the direct best interest of the children, without having all of the facts behind why they shouldn't have equal rights. I feel that 318 sets a precedence for creating that rebuttable presumption, giving it both parents the option to actually state and have to prove why the other parent shouldn't be able to get 50-50 custody. It shouldn't be a matter of fathers getting it, mothers getting it, especially nowadays where equality is such a huge, huge topic. The LGBTQ population doesn't fit into the current standard. with one side favored over the other based on how the law is written. That's not in the best interest of the children. Children need both parents, and unless there's a reason or a situation that presents that, they wouldn't allow the equal parenting time or rights. It should be a standard that both parents can do their due diligence and their duty to raise the children. Right now, it's setting a precedence for our children to understand that if they grow up, have kids, and get divorced, one side will get the children's custody of the children and the other one won't. Let's make a change sooner than later before it affects many, many more generations to follow. Thank you for your time.
Thank you.
Chairman Przansky, Senator Thatcher, and Senator Manning, I want to thank you guys for allowing this hearing to happen today. For the record, my name is Alexander Malloy. I'm a resident of Josephine County. I live in Grants Pass. I'm also a family coach for the Department of Human Services and a peer support advocate for parental equality. I'm here today to testify in support of Senate Bill 318 in my capacity as a citizen, not representative of the opinions of Department of Human Services or anything. But my job is relevant because the state of Oregon has simultaneously determined that I'm capable of helping other parents with family planning and determining what's best for their children in family planning scenarios. But when it comes to my own children, I'm limited to 4 days a month with them. Most people presume that in a court of law that you must have done something wrong in order to have rights taken away from you. And in my case, I pass every background check required to be an employee of the state of Oregon. So I try to find where what did I do wrong to get what I got with my children. The way the laws are currently written is a winner-take-all scenario. In my case, I filed to establish parenting time with my children under the presumption that I was seeking equal time with my children in an effort to share the responsibilities of raising them. Little did I know that my call for equality wasn't even in consideration when my ex decided not to agree to that. What Senate Bill 318 does is it broadens the toolbox available to judges to create parenting plans that are in the best interest of children when both parents are deemed fit. It does not create rules that would allow abusive parents more access to children or the potential for abuses to occur that otherwise wouldn't. I do ask that you consider the passage of Senate Bill 318, and I will submit the rest of my testimony in writing. Thank you.
Thank you very much. Any questions for the panel? Gentlemen, thank you very much. Thank you. I've got Jen Jacobson, Deidre Eden, and Donald Hudson next, please.
Ladies first.
How about Jen Jacobson?
Okay, I'm Jen. Thank you for having us, and I'm really nervous. I've never done this before. I'm here on behalf of all the, joinees say I'm Jen Jacobson. I'm here on behalf of all the thousands upon thousands of children who have no voice. I grew up with my father, so I did not have a mother. I was these children that we are discussing. As we all can agree that we all have a story. I grew up in abuse, and more is caught than taught. I did testify in court in Clackamas County with my father in the room, and it was terrifying as a child. But it was not in my best interest that I was with my father. As I said, more is caught than taught. Being in an abusive with my father, it ended me into an abusive marriage. I did not want to come from a broken home. We all hear that term, broken home, and I'd like to maybe redefine that, because you can have a broken home inside of a marriage that's broken. I was in an abusive marriage. I'm a mother of 3 boys, And I didn't know how bad it was until I had a Clackamas County Sheriff tell me in 2014, ma'am, you are not raising boys, you are raising men, and they need to know that this behavior is unacceptable. There is no one-size-fits-all approach. Just like with children in our lives, with their personalities, they're so uniquely different. So what works with one does work for the other. I am opposed of this, as I believe each case is uniquely different, and I do believe with everybody else that children do need to have their voices heard. Thank you.
Thank you. Who'd like to go next?
Thank you. Thank you. My name is Deirdre Eden, Clackamas County. I am part of a team which crafts safety for those fleeing domestic violence and human trafficking. The duties I have, they carry a trauma, and I carry that trauma stewardship. I have seen with my own eyes the very worst that humans can do to each other. Every piece of armor that I wear represents a child that I have been able to save. I serve men, women, and children, and I have friends on both sides of this debate. This bill is a poor attempt to put a Band-Aid on a gushing wound. This bill will not educate judges on the power and control dynamics of family violence, the effects on children, or the abuse of parents' final blow to the victim parent, and notice I keep it gender neutral, the victim parent by taking their children even half the time, meaning the protective parent cannot protect the kids half the time. Even documented abuse, police reports, CPS reports, these things are routinely ignored. This will not stop the judges that racketeer, the custody for cash scandals, the kids for cash scandals, and all of these are prevalent in our courts. Nor will it bridle the lawyers who charge by the hour to perpetuate conflict, who preach you can have as much justice as you can afford, and truth is measured by the weight of your gold. When the people on this side of the room, and this side of the room, and on both sides of this debate, when they stop fighting each other and start working together, we will see family court fall. Thank you.
Thank you. Donald?
Hi, my name is Don Hudson. I've been a welder, I've been an elevator mechanic, I am a military veteran, but above everything, I am a dad. I've been a dad for 27 years. I've been a full-time stay-at-home dad. I've been a working dad. I've been a dual working parent. I've been a part-time weekend dad. I've been a stepdad. I have been an estranged dad, but underneath it all, I'm a dad. And I can take this short time that I have in many different directions, but I'll focus on the fact that I am a stay-at-home dad. When my 3 young children, ages 3, 5, and 7, were all born, my wife, who was a very professional surgeon, worked ungodly hours, so I was it. She would leave Monday morning before the kids woke up, and they wouldn't see her again until Saturday. Not because she was gone, but that's just the hours she worked. They were in bed before she got home. She nursed the full time until all 3 of these kids were 2 years old. Breast milk, breast pumps. Oh my God, the amount of breast milk that we had in our freezer was ridiculous. But we managed it, and it worked. Breastfeeding and toddlers are still going to attach to both parents. Both parents are important. I am the one that my kids call for. And I think that's really the litmus, right? Who do the kids call for when they're sick? That's the primary caregiver. I think it was Ruth Bader Ginsburg that said, without true equality in the home, there will never be true equality in the workplace. Let's reach that goal. Dads don't babysit. We're parents. Thank you.
Thank you very much. Questions for anyone on the panel? Thank you all very much for coming forward. Our next panel is going to include Ryan Cartley, Sybil Hebb, and Judge Armstrong.
My first name. Okay. Chair Brzezinski, Vice Chair Thatcher, and members of the committee, my name is Sean Armstrong. I'm a circuit court judge in Marion County. I serve as the chair of the Marion County Family Law Executive Committee. I'm the judge member of the Marion County Domestic Violence Council. I'm a current member of the Parental Involvement and Outreach Subcommittee of the Oregon State Family Law Advisory Committee and a past member of the Oregon State Bar Family Law Executive Committee. In addition to my regular caseload in Marion County, I also presently run the entire self-represented family law litigation docket in Marion County. I also routinely serve as a settlement conference judge. I handle as many as 3 settlement conferences each week for family law litigants who seek alternative dispute resolution in lieu of trial. Prior to taking the bench, I was a shareholder at Garrett Heeman Robertson, PC in Salem, where I practiced family law for 14 years. These thoughts are my own. I offer the testimony based upon my experience as both a circuit court judge and a family law practitioner. I oppose Senate Bill 318 for 3 reasons. First, families and their needs are unique. When families are in crisis, as is often the case at the end of a relationship, they need courts to have wide latitude to craft a child-focused parenting plan. A bill that mandates an equal parenting plan in all cases ignores the wide variety of family and parent-child dynamics at play. Even in cases where no actual physical or emotional abuse occurs, families have varying power structures. Parents have differing skill sets. Children have a variety of needs based upon their ages, emotional maturity, and levels of attachment to each parent. The current state of the law appropriately requires the court to focus solely upon the best interests of the children without regard to what their parents perceive as fair. There is no evidence that perceived fairness is a reliable mechanism for predicting appropriate outcomes for children. 2, equal parenting time is conceived of here rarely exists in intact families. The presumption of equal parenting time is not the reality for most families who have long ago figured out who will serve as the primary parent, who will handle medical appointments and school counseling, who will prepare meals for the children, bathe them, dress them, and take them to school. In my experience, these tasks are rarely equally shared. While children are undergoing the difficult transition from intact to separated family, they need above all else a stable and effective transition that relies upon education and skill building for the parents, rather than an artificial plan that would rarely reflect the reality of their intact family childhood experience. And 3, this bill would shift the focus of litigation from a child-based model to a parent-based model. I'm going to go off of my written comments and just talk very briefly about this. I spend hours educating family law litigants, whether represented by attorneys or not, that custody and parenting time decisions are not made based upon attacking other parents' skills and abilities. That is the focus of parenting time for most people. It's incorrect. When you have a law that requires that you prove that a parent has performed poorly, you are increasing the level of litigation, and you are going to see essentially heightened litigation in which each parent will be forced to attack all of the other parents' skills and weaknesses in order to overcome this rebuttable presumption. That will increase litigation and enmity between families and will prolong the trauma of divorce. Thank you.
Thank you.
Chair Brzezinski, Vice Chair Thatcher, members of the committee, my name is Ryan Carty. I'm an attorney in private practice here in Salem. My practice is limited exclusively to matters involving family law. I am the current legislative liaison for the family law section of the Oregon State Bar, and I also serve as chair of the legislative subcommittee for the family law section. It is in my role with the Oregon State Bar that I appear before you today. The committee has heard numerous sympathetic anecdotes and individual stories via testimony today, and I am confident as you leave the room and continue on, you will be presented more of those. But it is important to temper these examples with the reality that both in the state of Oregon and nationally, approximately 80% of the cases involving both custody and parenting time are resolved by the stipulated agreement of the parties. That means in the vast majority of cases, the current legal framework supports resolving issues in a manner that parents can agree to and that they can agree to fosters their children's best interest. Parents in every judicial district in the state of Oregon are required, as part of their family law case, to participate in parent education programs and mediation. Those programs and processes present, in essence, a blank canvas for those parents to work collaboratively and cooperatively to achieve outcomes that are good for their children. And it's one that lawyers and judges and court staff throughout the state encourage and endorse. And it's one that exists as the law exists presently today. Imposing a statutory presumption of equal parenting time replaces that blank canvas with what is in essence a color by numbers project. Because what it does is it removes the creativity and the proposed communication and collaboration that is encouraged by our current process.
Ryan, I do need you to wrap up.
I'll wrap up just by saying it is absolutely a fact and demonstrated by numerous longitudinal studies over decades of work that equal parenting time is not only appropriate, but preferred in families where they have appropriate supporting factors. You can read about those supporting factors in my written testimony, but I will suggest to you to conclude my remarks that in the absence of appropriate protective factors, mandating equal parenting time for families in the state of Oregon will increase conflict among families, and exposure to conflict is detrimental to a child's well-being. Thank you.
Thank you. Sybil?
Thank you, Chair Przonski, Vice Chair Thatcher, members of the committee. Sybil Hebb with the Oregon Law Center, here to present excuse me, concerns about Senate Bill 318 from the perspective of the low-income individuals that we serve who are our clients seeking safety and stability for their children in the aftermath of a separation. A significant percentage of our clients are fleeing domestic violence or have suffered sexual assault in the context of their relationships, and so that creates a heightened safety factor that is important to the Law Center in helping families move forward. I'll be brief, and I echo the comments of the two witnesses before me, and I guess what I would say is that I agree there have been compelling, quite a number of examples of cases that cause concern. My worry and significant concern is that imposing a presumption that cannot be rebutted except by tearing down and proving unfitness with a high burden of evidence of the other parent is something that would cause more problems than it would solve. And in my view, not speaking for any of the proponents of the bill, of course, but in my view, listening to these stories, I think that they are examples that prove that our systems of justice need more resources and more access to services and assistance for those who are trying to use them. To Ryan's point that most families do not end up in a conflict scenario going through the court system. Most families are able, generally speaking, numbers-wise, to come to resolutions on their own. We need to focus on those parents who are unable to come to agreement, many situations in which there are substance abuse issues, domestic violence, past assault, mental health issues, you know, the whole gamut, not to mention just purely the circumstances of people's lives, given their work schedules, their financial capacity, and many other circumstances. So my view is that this bill is a place where we could work together on issues like Senate Bill 371 and 385 and others that provide parents with resources so that they're better able to come up with solutions that meet the needs of children, and that children's needs are the appropriate best focus of all of our responses. So thank you very much.
All right, thank you all very much for coming forward. Our next panel is going to include Jens Matson, Steve Green, which I thought we had Steve. Do we have a second Steve Green? I have one that was spelled with an E on the end, the other without. If it's the same person, we'll hold off. Let's go with Jens, Brandon Johnson, and I will take Joel Tollefson, I believe it is. Jens, why don't you get started, please?
My name is Jens Madsen. I'm from Douglas County. I have been separated from my son's mother for 4 years. Initially, when she left, I was not allowed to see my son unless I was to give her money or buy her something, things of that nature. Within 3 months, I went to my attorney, we filed a status quo, and I was granted sole custody of my son. I believed that my son also needed his mother. So I agreed to 50-50 time with my son and his mother. We went through a custody evaluation. My son expressed that he did not want to live with his mother. He loves his mother, but he does not want to live with his mother. My son expressed to the evaluator that my dad brushes my teeth at night. My dad does all the cooking in the house. He cleans the house. My dad works very hard. My dad teaches me things. My dad spends time with me. He takes me fishing. My son tells the evaluator that my mother lays in bed and turns the TV on, so I'll lay with her and watch cartoons. The custody evaluator sided with my son's mother. I was granted every other weekend and every other Friday time with my son. I get my son back. He is just tickled to death, just happy to be home with me. With the short time I get to spend with my son, I spend it trying to patch the damage that his mother has done. My son has been terrified to live in my house at times because his mother has told him that there are demons that live in the house. My son used to sleep and share the bed with us when we were together. When he was 7 years old, I finally talked him into finding the courage to sleep in your own bed. He was so proud. Mom, guess what? I'm sleeping in my own bedroom. The next words out of my ex-wife's mouth were, honey, I'm proud of you, but make sure your dad locks all the doors and windows so the bad people won't get you. I still deal with this. To spend time with my son, trying to let him do things that a boy wants to do. My son races cage carts. He loves it. He is so happy. He has developed so many strong friendships with other kids at the track. It is like a family. It's an extended family there. Kids will go from one race trailer to another race trailer. One parent will bring cupcakes, another parent will have sandwiches, another parent has juices. But we do this together.
Jens, I need to wrap up, please.
Okay. My son, he is now terrified to go to the track. He doesn't want to be there because he's afraid that his mom and his grandmother will punish him because he wants to race. The last time we went to the races, he was so excited. He got in his car, he went out there for practice. When it came time for him to start racing, he kept asking what time it was. What time is it? Once when it got closer time for the racing to start, he started hiding in the race trailer. I told my son, no, son, we're going to stay here and we'll watch. I want you to see your friends race a little bit. We're sitting in the stands watching.
Jens, I do need you to wrap up, please.
Anyway, basically what I'm getting at is co-parenting would work in most cases. Some cases it won't work. If I had my son at least half the time, I could keep him on a straight and level path. The way it is right now, I spend the weekends just trying to repair the damages that his mother and grandmother have done. Thank you.
Thank you. Who'd like to go next, please?
My name is Joseph Tollefson. I'm from Staten, Marion County here. I appreciate the chair for listening to everyone and the voices that we have here today. I worked for the, a bit nervous, Oregon Youth Authority for the past 20 years. I'm speaking on my own behalf. I simply mention that because I care for other people's children all the time. Sorry. what I'll say is I started as a 50-50 parent. And because my ex decided that that didn't work and that she could play the system by claiming that we couldn't get along on things anymore, she was able to change that in the court. And exploit what I consider a broken system. I'm going to leave it at that. I would like to present you with a written testimony, but I'm sorry. Thank you.
Joe, please take your time. Since we have till tomorrow, 5 o'clock, if you'd be so kind, we'd love to have that testimony.
Yes.
Hello, my name is Brandon Johnson, and before I start, I want to talk about my childhood. I was born in Klamath Falls, Oregon. My mom and my dad did not work out, and so my mom decided to up and move to Walla Walla, Washington, about 7 hours or so from Klamath Falls to Walla Walla, where she lived with family. Due to that and courts, my dad was only given weekends, and it's pretty hard to drive 7 hours one way, spend a little bit of time, have to drive right back, especially when you're working. So because of the system that we have, I grew up without a father, and I definitely don't want the same to happen with my children. I'm a proud father of 3 boys. I have joint custody and primary care of my oldest. With my younger 2, however, I'm fighting, struggling, and begging just to be a part of their lives. As of now, I see them every weekend. So if I could get equal rights to decision-making, things would be pretty good. However, their mother is trying to make it to where I have no rights to decision-making and only get to see them every other weekend. And if you're a parent, truly think about only seeing your kids 4 days a month. If the child truly loves both parents, we're damaging them by allowing such little time together. If coming into a courtroom, you see 2 loving parents who try their best to raise their child with love, compassion, bravery, respect, and all the other wonderful qualities we want for our children, and your first response isn't 50-50 custody, and that's saying, in my case, that the love that I have for my children is less than the love that their mother has for them. That's what's being said without even knowing her or I by the courts. That's what she's hearing, and that's what my children are hearing. But I'm not going to accept this because I'm not a part-time parent. I'm broken and tired of my children asking why they go so long without seeing their brothers and I, and having to fight back tears as I explain if I had it my way, I would see them every day. 50-50 custody isn't a win for one parent or the other. It's a win for the children to have the 2 people they love most equally in their lives.
All right, gentlemen, thank you very much for coming forward. We have 6 more individuals that are signed up to testify. I know I have committee members that have other tasks and duties that they may need to be leaving. We're actually over the time that we're supposed to be here. The chair is going to stay here to hear the last 6 individuals testify. Other members, if you can, please do so. We will have a complete record that others will be able to do so. So at this point, I'm going to go ahead and call up, I know we have a panel that wants to end, that's 4.
I can get into this before these folks leave.
Yeah, that we all came a long ways to speak to all of you.
If you didn't hear me, I did say that I'm going to take all of the testimony. If you keep on talking, we're going to have less and less time. Please let me just get through the list, and you're on the list, and we're going to take care of it.
I hope you're not leaving, is what I'm saying.
So we'll go ahead and call up Isla. Why don't you come on up, and Ernie, and then I have Tom Bushman and Thomas Bushman. So what I'm going to do is have the first 2 come up, and Joseph, you come up, make up that 3, then we'll bring up the 2 Bushmans together. All right?
Thank
Go
you.
for it, Joseph.
So I guess I'll go first. Joseph Cowles, reside in Lane County. I apologize. I had signed up for 3 different bills, so I'd expected to talk on 3 different bills, 2-minute intervals. I didn't realize that 318 and 736 were combined. Parenting time. 50-50 parenting time, the presumption of 50-50 parenting time, 20 states have done this. There is a presumption in 20 states. I'm going to leave this map in the back there for everyone to see that it has been done. There's significant precedents. A loaded argument for, well, actually, there's a three-pronged approach that I've been really pushing for as initiatives, and I was part of this last work group. The three initiatives are presumption of 50-50 parenting time, getting rid of the damn term custody that is antiquated and means imprisonment. And when prisoners are taken into custody, they're allowed visitation from family members. Those are not the terms we should be using for our children. Instead of pouring gasoline onto the fire, as both the state and litigation and attorneys do, there is an alternative solution: giving children a voice. Presumption of 50-50 parenting time, unless there is something fundamentally wrong, unless the other parent is fundamentally unfit, not because of a loaded argument, which is typically the case. Getting rid of the word custody, replacing it with its definition: decision-making responsibilities. That is what custody is. Those four decisions are already identified in the state of Oregon: education, religion, religious training, healthcare, and residence. What I have proposed to the work group was to allocate, give the court the power, instead of it being black and white, adding the color of nuance. It should not be all or nothing, zero-sum game of custody, 50-50 or a weighted average, primary caregiver, secondary caregiver. We are all parents. I'm going to go over because I thought I was going to talk about both, and I'll be as quick as I can.
Joseph, you need to wrap up. You have testimony already presented here in writing.
Okay, I will. So, in conclusion, giving children a voice, presumption of 50-50 parenting time, allocating each of the decision-making responsibility. The court can use its own conservatism and allocate all the decision-making responsibilities to one parent if the other parent has proven unfit, the exact same as sole custody. So what I propose gives the court that power to allocate all the decision-making responsibilities the same as sole custody. It just empowers the court with more opportunity and power to do the right thing on a case-by-case basis. Thank you.
Thank you very much.
Go ahead.
One last thing, Senator Przonski. There are three members that I had written a book, Broken to My Path to Half, and it talks about the resistance I felt in the second work group, and in fact 318 was not supported by the second work group. This came from Senator Thatcher, Senator Manning, and Ayla Hoffler, and I thank you very much.
Ernie?
I'm autistic, so this is my first time being. Thank you, Senator Chair Przonski, for giving us this opportunity. My name is Ernie Young. I'm also speaking on behalf of my beloved son, Zebulon Adagio Young. I promise you that I didn't come here to cry, but I came here to tell my sons and my story, which will move and touch your heart, but will also affect your heart in ways that no one would fathom. And as his father, I don't even want to fathom it. This bill, SB 318, needs to pass intelligently and logically, for the simple fact that it will provide continuous, constant, and meaningful contact for a parent and child each. What my son and I have endured is his mother and her sister, his aunt, who's a Child Protective Service caseworker. They filed 7 protective orders against me in less than a year and a half. In less than a year and a half, along with 2 fabricated juvenile petitions stating that allegedly an unsafe behavior is me taking my son to a doctor to have him examined for non-accidental trauma. That's allegedly an unsafe behavior in a mandatory reporting state. And that somehow that causes mental and emotional trauma on 4 visits. And especially when the medical professional is stating that this is non-accidental trauma, and his medical directive is when you see this trauma, you bring him to the doctor. And when the medical professional is contacting DHS, I apologize, they're ignoring it because of the conflict of interest, which violates my fundamental parent right to protect my son because he is my liberty to protect. And I currently have a 50-50 parenting order, as I was even awarded sole custody at the first custody hearing because mom was not granted any parenting time because of abuse. I'm sorry, didn't go the way I wanted it to. Fact is, the Judge Bloom in Jackson County has denied me 3 immediate danger orders to protect my son from mom and her significant other. Okay? I have that 50-50 parenting order protected right now in the Court of Appeals because I was smart enough to know that they were going to mess with me again.
Ernie, I need you to please wrap up. I know you have your testimony.
I understand. This bill or law, if I had my son the same amount of time, I'd know what he was going through. Right now, I feel that Jackson County CPS, they're kidnapping my son from me. All my son wants to do is to come home. That's it. If you have any questions for me, otherwise, I have provided testimony for you guys to look at, and I'm sorry.
Thank you for coming here. Nothing to be sorry about. We appreciate you being willing to come forward, and thank you for doing the written testimony.
And I have photophobia, so that's what my son and I look like together.
Okay, thank you. Ayla.
Ayla Hoffler, Washington County. Chair Prozansky and other senators, thank you for staying over. I appreciate you being here in person. I had wanted to do a little visual exercise with you for you to imagine yourself as a primary provider in a relationship where you have a child or two. And that means that definition is you're the person that puts the roof over the head, food on the table, health insurance, etc. You made an arrangement with your significant other, the other parent, to get to be the primary caregiver. Well, that's all fine and good when you're getting along. So imagine yourself now, your significant other says they want to be separated from you. Okay? So you walk into, you get the lawyer, you drop $30,000 to try and save what you can. And I'd just like you to think for 1 second, what's the first thing that comes to your mind when you know you're getting separated? You panic, you're in shock, you're angry, but most of all, you're scared to death. Why? Most people would say, I'm scared to death, I'm going to lose my kids. I'm not going to see them. And that's what you pay the big bucks for. And then you go into the family court system, and it's a crapshoot. There is no consistency judge to judge, county to county. There is no state guidelines that sets mandatory status. This should be looked at like a football game. Where do you start? You've got opposite teams, but you start on the 50-yard line, right? And that's what this bill does. Everybody gets 50-50, unless you have credible, clear, convincing evidence that somebody is unfit. That's not hearsay. That's not a deadbeat mother, and I'm going to take a couple more minutes.
No, you have
gonna,
testimony. I have 3 other people who are waiting to testify.
Thomas is giving me his 2 minutes.
No, Ayla, I need you to please step down. You have testimony. I have other individuals that have signed up and that said they wanted to give testimony.
Right.
And so please step that back.
They're coming.
And you have testimony written. If you want to supplement it, you can put it more in.
And if
Thank
Thomas
you.
gives me his 2 minutes, can I use it?
It wouldn't be fair for everyone else that's come in that day.
Last person, sir.
You need to please step back. My next 3 witnesses that I have is Thomas Bushman, Tom Bushman, and then I also have Kim Tolleveson. Kim, would you be so kind to start?
Yes, sir. Thank you, Chair Prozansky, and senators for hearing us today. My name is Kim Tollefson. I am a nursing professor and also I have actually experienced domestic violence and have an active stalking order with my ex, as well as being married to Mr. Joe Tollefson, who you tried to come and speak for you guys today. It's night and day being with somebody like my ex and Mr. Tollefson now, and I'm here to support him primarily. I speak as domestic violence survivor because I understand some of the concerns about 50-50 parenting and how people concerned that that might affect somebody coming out of that kind of environment. I feel like when there's documented cases and actual evidence to support that, that needs to be seen and heard by the courts and addressed. But outside of that, I've also seen in our case, last 3 years almost, we've been fighting this battle over him having access to his children because they're in Klamath Falls and she chose to move there, and we've had CPS allegations and everything, and they've all been unfounded. And I think in those cases, when they're unfounded, they should not be heard and considered in considering custody. They started out initially with a 50-50 parenting agreement, but his ex-wife very quickly determined that if she doesn't agree, she wins. She can go into court and say, we can't get along. And she was able, we were told by our attorneys, the court predominantly leans for the mother. Unless you can show that she's unfit, you're not going to get those kids. We have concerns about them in her care. We can do nothing about it. But where my husband used to be able to talk to his children every night, through the course of parental alienation and withholding visitations, she's managed to get it so he might get to talk to them a couple times a month. When we get our standard monthly visitations, she's not showing up. This gives him an opportunity to find some balance in the court system so that when you go in, there's not automatically an expectation that one parent's going to win. There's going to come in with the expectation that the parents should be working together to find a means to do things that works for the best interest of the kids. Instead of it being which parent's going to win, it's going to be how do we win for our kids.
Thank you very much. So, gentlemen, who would like to go? Tom or Thomas? Tom?
Good morning, panel. My name is Thomas Bushman, Jr. This is my son, the third. We're from Jackson County. I'd written some paperwork that I've been over and over and over and over many times. And what I've heard from the people, everybody here that's a father,
Thomas,
mother that's missing your people.
Thomas, we're trying to get you on the record, and so if you'd be so kind.
Oh, my name is Thomas Bushman from Jackson County.
Yeah, we've got that.
I just want to say, though, that what I've heard here from the fathers, I'm a grandpa, and I lost a grandson. And when my son has gone to court here in the past to try to obtain custody with his child at the beginning, accusations that enter a courtroom from his ex that are told to a judge, there doesn't have to be any factual information at all from that individual. All she has to do is open her mouth and say, this happened, because I know because it happened to my son. When my son asked for 50-50 parenting time, the judge automatically, Judge Hopping in Jackson County, gave her full custody. I told my sons, you have all the rights as a father. What does that mean? That doesn't mean anything. That means he gets to see his son Tuesdays and Thursdays for 6 hours a day. It took him 10 months of fighting to get that.
No, after the 6 hours per week.
6 hours per week. So after 10 months of fighting, unfortunately, getting those few hours wasn't quick enough for him, because on November 29th, we got a call that his son had swallowed something at his mother's house. He's flown the Dornbeckers and died. And while his son was dying, his ex tells him, no, you don't get to spend time with him. Only me and my current husband do. Since when does a biological father not be able to stand by his son when he's dying, but a non-biological dad does? This is my son. I'll let him tell his story.
Thank you. Thomas.
My name is Thomas James Bushman III. Like my father said, I had a little boy. His name was Thomas James Bushman IV. His nickname was Ty. He passed away December 2nd, 2017, from choking. The autopsy showed that he had a part of a syringe shoved down his throat and ended up dying. During the time at the hospital, I actually was not able to see my son because I did not have the parenting time available to see my son. that hurt me extremely. And to this day, I don't understand why I could not see my son during those final moments of his life. All I wanted was 1 hour. I asked for 1 hour. I don't care if it was supervised. All I wanted was 1 hour with my son. That's all I wanted. He was a 2.5-year-old boy. I got 6 hours a week. Just 6 hours, man. Just 6 hours. All I wanted was more. All thing I can say is just please give fathers more than at least 50-50. That's all I ask. Thank you. It's our children. I have no criminal record. I've never hurt nobody. Never done anything wrong in my life. And just because of an accusation, because I was depressed, I get 6 hours a week. Just 6 hours. Because I have an accusation, because I'm depressed. I don't think that's right. I don't think it's right at all. So please. Just support the bill. That's all I can ask.
Thomas, thank you very, very much for coming forward. I know this is very difficult. I want to thank everyone that's come forward to give us their personal stories. As heart-wrenching as they are, they're important for us to hear. Again, if you have more testimony you'd like to submit, if you felt like you wanted to say something but you didn't testify today, please put it in writing. You have till tomorrow at 5 p.m. To have it. And again, our staff will be more than glad to help you go through the system to make certain it's part of the record. With that, we're going to be adjourned till tomorrow at 8 a.m.